The comments that were made from the Chair by the Minister, and I do acknowledge and appreciate the faith that she's invested in our youth court judges, because when she was speaking about the reason why children would be dealt with appropriately in the youth court, she felt, I think, adequately. I guess she felt that it would be a safe option because of their high quality and their high calibre. Now, I share that trust in those judges, which is why I listened so carefully when they appeared before the Select Committee and gave us their view on this fundamental change to our youth criminal justice system. And I use the words fundamental change because that's a language that they used. They said this was fundamentally reorientate the way that we deal with child, I make that distinction, child and youth offenders. And what did they tell us? They told us that with regard to 12 and 13-year-olds, that they did not feel adequately equipped in the youth court to deal with those young offenders. They said that they did not believe they had the ammunition, the appropriate ammunition to deal with those child offenders, 12 and 13-year-olds. So if the Minister genuinely places the trust in those youth court judges and believes that they are good at what they do, why did we not heed their advice from the beginning, and why did we make this fundamental change? Now, that's something that has that stayed in my mind throughout the Select Committee process. Why were we making this change? Well, the first question I thought would be relevant to that would be to size the problem, and Annette King has already talked about that. We asked at great lengths at Select Committee how many children would be affected by this change. And you heard the answer. We got an answer of 80 apprehensions. Now, that doesn't mean 80 children. That means 80 apprehensions. And because of the fact that, for instance, of those who went through Te Hurihanga, some of them had up to 30 offences in their own name, we could be talking about a very small pool of people, of children that we are talking about here. Now, some might say that the number didn't matter. Well, it did matter to the government when they said that we should close Te Hurihanga because it wasn't dealing with enough people. Well, here we have an example of an entire piece of legislation orientated at probably the same size of young people, children in this case. But for me, and I think for the members of the committee from Labour and for the Labour Party generally, if the Minister cannot give us an evidence base for this fundamental change, if we can't even quantify the number of children that would be affected by it, why are we making it? If the youth court judges who we are giving the powers to resist them, why are we making it? Well, I came back to, I guess I was charitable and wanted to come back again and ask perhaps a different question. Was it simply, as the government claimed, that the family court didn't have the powers they needed and that there would be more powers in the youth court? Well, I thought, why don't we look at this differently? If the family court is the power of care and protection, which is a crucial power, which even the youth court judges have said is crucial when dealing with all young offenders, but particularly 12 and 13-year-olds, but all of them, why did the government not look at giving greater powers to the family court? Why did we not look at that option? And we asked that question not only of officials whose response to us was that it was simply out of scope, we asked that question to the youth court judge and the family court judge, and both said that would have been an elegant, I quote, an elegant solution. If this was really about dealing appropriately with those child offenders, why did the government not shift powers to the family court? I fear it was about moving the goalposts. I fear that it was about acknowledging on the government's part that we don't know how to deal with these child offenders, so we will move the goalposts and start dealing with them as they were adults at a younger and younger age, and that changes absolutely nothing. That is why the Labour Party, the opposition, have tabled today an SOP which will remove these clauses around 12 and 13-year-olds. And we'll be voting strongly against this element of the bill because of what it stands for, because it is a fundamental change, because it has not been justified, and finally, because it will not work. We have a tiered system in New Zealand, and now, Mr. Chair,
Jacinda Ardern.
Thank you, Mr. Chair. We have a tiered system in New Zealand in our criminal justice system when dealing with young people, and I fear it's becoming murky. And we've already talked about the fact that this actually could make it worse. The outcome for these young children could become worse. But I do want to move on, though, onto another part of Part 1, and that is the additional orders that we're looking at in this bill. And they come under Clause 8, Section 259A, which says that family group conferences must consider attendance at parenting, education, mentoring and alcohol drug rehabilitation programs. Now, this is something that's being widely trumpeted by the government as an important way of dealing with young offenders. And I would like to believe that perhaps these had a chance to make some difference, but I have some grave concerns. And I think some of those were highlighted by the report that we saw released by MSD this week that said that court orders had a very low success rate. And I think you can see some of the reasons why, when in comparison, intensive residential with activity programs had a better success rate. They were longer term, there were greater interventions, they dealt with the family as well and the social circumstances under which that young offender was coming from. Whereas court orders are quite the opposite. They can often be quite short term. They can, for instance, be short, sharp shocks. For a drug and alcohol program, they can have quite loose arrangements around them. And in fact, I spoke to some young people who had undergone court orders which were specific to drug and alcohol issues, and they simply told me they sobered up for the short time that they had to be in attendance and that they did nothing. The ones that did work were longer-term residential-based drug and alcohol programs like those provided by Odyssey House. We heard at the Select Committee that Odyssey House has a 12 to 18-month waiting list. They do not have the funding currently to deal with any of these potential court orders, and I would question whether how many would be residential anyway. I asked the Minister if she would stand on her feet at the next opportunity and tell us what additional funding the government is going to commit to drug and alcohol programs, because already I know of a few that have closed under this government's watch, and yet we're going to be extending the amount that they're being used. Dunedin, there are drug and alcohol programs that have closed on this government's watch. And on the submissions, I'm happy to reflect back for the Chair that, for instance, a submission by Dr. Sue Babtor that said already there are not nearly enough placements in youth alcohol and drug programs. And those from the Alcohol and Drug Association New Zealand that said that we recognise that staffing is a primary consideration and recruitment of staff is a serious challenge facing youth services presently in New Zealand. We have to make sure that we're prepared for these orders, over and above whether or not the question of whether they'll work. Judge Andrew Breakoff has already told us that 80% of young people coming before his court are manifesting some kind of drug and alcohol issue. But we are only dealing with those who are coming before us once they've committed a crime. There is a whole debate in this about what we're doing to intervene in these young people's lives before they get to the court. Secondly, the mentoring programs. I'd like the Minister to share with us, if she could, the outcomes of the mentoring hui which she had, because I know some of the concerns that were raised at that hui were around whether or not mentoring would work if there was an element of compulsion. It's something I've heard from those who have worked in the field, whether or not we'll lose the success of mentoring programs if compulsion is a core element. Whether or not volunteers will be adequately trained to deal with some of the quite weighty issues that these young people have who will be going through these mentoring programs. How long the mentoring programs will work for or be issued for, because again, some of the people in this field I've spoken with have said that 12 months is a bare minimum, and some of the most successful interventions I've made have been around mentoring relationships that have lasted up to 6 years. Can we genuinely expect that from these mentoring orders? Because I have serious doubts. And thirdly, I also have concerns over an omission. An omission that was pointed out by Judge Andrew Breakoff again when he came before the Select Committee and said that nowhere in this legislation has there been an adequate discussion about the mental health issues that a lot of these young people are presenting with. We already know about the dysfunctional family issues, about family violence, about poverty, social deprivation, lack of engagement in education, lack of employment, and the contribution that makes. But mental health is increasingly an issue that these youth court judges are coming up against time and time again. And they pointed out to us that they do not have adequate programs to refer these young people to.